interview of the candidates for the position of Associate Justice of the Supreme Court, Vice Honorable Estela M. Perlas-Bernabe. We will start with the centennial prayer for the court.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
It is my honor to introduce to you the members of the Judicial and Bar Council. Honorable Chief Justice Alexander G. Gesmundo, ex officio chairperson representing the Judiciary. Honorable Justice Jose Catral Mendoza, chairperson of the JBC Executive Committee and regular member representing the retired justices of the Supreme Court. Honorable Judge Toribio E. Ilaw Jr., regular member representing the private sector. Honorable Justice Noel Jimenez Tiham, regular member representing the academe. And Honorable Judge Franklin J. De Monteverde, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Chief Justice and ex officio chairperson of the JBC to officially open this public panel interview.
Good morning, everyone. This morning's public panel interview of candidates for the position of Supreme Court Associate Justice is hereby declared open.
Your Honors, the candidates to be interviewed this morning are Court of Appeals Associate Justice Maria Elisa S. D, Court of Appeals Associate Justice Apolinario D. BRUSELAS Jr., and Court of Appeals Associate Justice Ramon A. CRUZ. Candidates, Your Honors, please stand up and please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. Your Honors, the first candidate to be interviewed this morning is Court of Appeals Associate Justice Maria Elisa S. D. The first to interview Justice Maria Elisa S. D. is the Honorable Chief Justice Alexander G. Gesmundo.
May we request the two other candidates to be seated at the lounge? Thank you very much. Good morning, Justice Lisa.
Good morning. Chief, would you like me to remove
Feel
my
free
mask?
to remove your mask.
Thank you.
So how are you this morning?
I'm okay.
Good.
I'm okay, Your Honor.
I have just a compound questions for you. In your personal opinion, what is the most pressing issue or concern affecting the judiciary that the Supreme Court must address? Why and how do you propose to address this issue or concern? Thank you.
The Supreme Court, when I was a student, Your Honor, it apparently looked that the Supreme Court is quite distant from court users, especially before, during older times. But I noticed that through the years, through the leadership of the Chief Justices, Chief Justice De Castro, Chief Justice Peralta, and Your Honor, we have been closer to court users We have given them a chance to discuss matters through seminars, even press events, Your Honor, as regards certain acts of the Supreme Court. And that would help them a lot, the court users, in their day-to-day lives.
Thank you. That was my only question.
Thank you, Chief.
Justice D, before we proceed with your next interview, we will first call on Justice Ramon Cruz to give way for the interview of the Chief Justice. Thank you.
Please be seated.
Our next candidate to be interviewed is Court of Appeals Associate Justice Ramon Cruz. The first to interview Justice Cruz is the Honorable Chief Justice Alexander Gismundo.
Thank you, Attorney Cuevas. Sorry for the change in sequence of interview because I have to attend the en banc at 10 o'clock. So let me ask you a compound question. In your personal opinion, what is the most pressing issue or concern affecting the judiciary that the Supreme Court must address? Why and how? What are your recommendations to address the issue or concern?
But basically, I look at clogged dockets as a basic problem besetting the judiciary. So my solution there is to limit the cases that goes to the court. The court must really be discriminatory in accepting cases without necessarily closing the doors for litigants. I guess this is a question of management, like what the court is doing now, where litigants really could not technically demand an appeal on the cases that are filed with it. So, cases emanating from the first level courts, which a litigant has lost, then he appeals it to the RTC. Then he goes to the CA. So it has gone 3 times hearings already. So chances are, I would suggest that the Supreme Court would look at it with some jaundiced eyes. Also, in cases coming from quasi-judicial bodies, where the quasi-judicial bodies have disposed of it, and the decision of that body has been sustained by the CA. And I also, in that same situation, I would venture to say that the person appealing to the Supreme Court really has no chances of his appeal being sustained. The next area that I also would look as a problem is uh, the area of jurisdiction, where although lately it has been the policy of the policy of the Supreme Court where confluence or concurrence of jurisdiction has been eliminated. But for some time that has been the problem visiting the court, also the judiciary. There are also there are situations, budget constraints, I guess, could be solved how the judiciary would make representation with Congress. But that also is a big problem that the court will have to tackle. The equipment, because without the necessary funding, the technology that the court really has to live with is drastically affected.
Thank you, Justice Mon. Good luck.
Thank you, Chief Justice Gesmundo. We will now continue with our public panel interview of Justice Maria Elisa D. Thank you, Justice Cruz. The next to interview Justice D is the Honorable Judge Franklin J. de Monteverde.
Thank you, Attorney Perlas. Yeah, good morning, Justice.
Good morning, Your Honor.
Let's go first to your medical report. It's dated March 31, 2022. It states here that you have a slightly elevated serum cholesterol, triglycerides, and VLDL, or bad cholesterol. Can you expound on this, please?
Your Honor, during the pandemic, it was very difficult to choose healthy food, Your Honor, because of the limited choices. And there were times when I had to eat the bad food. However, our family doctor, who is actually my cousin, already gave me also vastatin for the cholesterol. And I hope that it has already worked, Your Honor. After I took the tablet for 2 weeks.
So considering that we are now on alert level 1, is there a chance for you to improve your condition?
Yes, Your Honor.
In what way?
In what way, Your Honor?
Yeah.
This is the time for me to go back to exercise, Your Honor. During the pandemic, I would limit myself to a gym. I have a small gym in the house, Your Honor, with an elliptical machine and some free weights and a stretching machine, Your Honor. But that's not enough. I know that maybe I should go back to jogging, as I used to do. We used to have runs, fun runs, Your Honor, and maybe badminton. Yes, Your Honor.
Now, Justice, the Supreme Court is a court of law. Its primary task is to resolve and decide cases and issues presented by litigants according to law. Are there instances when the court may apply equity in resolving and decided cases?
Yes, Your Honor. Actually, when I took a look at the internal rules of the Supreme Court, it is explicitly allowed that if there is no applicable law, no law applicable in a certain set of facts, then equity may be applied, Your Honor. And that is the rule that we have in our laws, Your Honor.
When there is no law, are there other instances aside from this? The one that you cite?
I believe that when substantial rights are in danger, Your Honor, then equity may also be applied, especially fundamental rights under the Constitution.
Can equity be availed of due to a gap, silence, obscurity, or vagueness of the law that the court can still legitimately remedy?
Yes, Your Honor. That is a situation that calls for equity, an application of equity.
Okay. Now, there is still a bill pending in Congress that seeks to revive the death penalty. Your view on this, Justice?
I have heard about that, Your Honor, in the past when I was reading current events. But I think it is still yet to go through the Senate, if I'm not mistaken.
Yes, still pending. So your view on this?
My
What
view.
is
Well, in all honesty, Your Honor, I have been oriented in a Christian way, Your Honor, ever since I was young. And my belief is that there should be no death penalty, Your Honor. That's why before we had it, no, in People versus Echegaray, and I think he was the only guy, he was the only person who was subjected to lethal injection. And it was, I was quite sad because of that event, Your Honor, because I believe that people can always change and should be given a chance to change, Your Honor.
Okay, let's shift to another subject. And this is the divorce bill pending also. Your view on this?
The divorce bill, personally, Your Honor, I don't think it can pass, Your Honor, because of our respect for the institution of marriage. It's in the Constitution that marriage is an important element of the family, Your Honor. And hence, it will be quite difficult for a divorce bill to pass in Congress, Your Honor.
Okay. Now, are Articles 1 and 2 of the Family Code on the definition of marriage discriminatory against the LGBTQ community and a violation of the Equal Protection Clause?
It is clear, Your Honor, that marriage is a special contract between a man and a woman based on the Family Code permanent union. But I do believe that it is not discriminatory in that sense, in the way that you have fashioned your question, Your Honor.
Yeah.
Because, let's say, two individuals of the same gender are in love and would like to enter into a permanent union. There are provisions in the Family Code for co-ownership and joint union based on property of two people of the same gender, Your Honor. So that can still be applied, the co-ownership principle, Your Honor.
Now, can the court entertain a second motion for reconsideration? If so, when?
The general rule, Your Honor, is that it cannot. It is very clear in the rules that a second MR cannot be entertained.
Is there no exception to that?
Well, in my experience as a judge, I have not experienced or encountered a compelling reason for the acceptance of a second MR, Your Honor.
Okay. Kindly review Rule 15, Section 3,
Yes, Your Honor.
and motion for reconsideration. Justice. How should access to justice issues be addressed?
Access to justice issues.
Be addressed.
Something to do with how the court users would be given chance or opportunities to access the courts, Your Honor. So in like, of course, we have to have a balance, Your Honor. Like, of course, we do not want the public to follow up cases. However, we should give them a feeling or an atmosphere that the court is not indifferent toward them. Like, let's say the judges, when litigants would like to inquire with the staff of a certain judge, they should not be, the staff should not be cold or indifferent toward them, but should have an attitude of being helpful, an openness to help the court users, Your Honor.
How long have you been with the Court of Appeals, Justice?
10 years, Your Honor, last February 21. That was my 10th year anniversary.
Okay. So how is your relationship with the appeals?
Actually, Your Honor, to me, the Court of Appeals seems to be the happiest workplace that I've ever been, Your Honor, because of the harmonious relationship among peers.
Okay. In the division or in the entire Court of Appeals?
I think in the entire Court of Appeals, Your Honor. I believe that all the magistrates, especially the senior ones, they always seem approachable to help the juniors to adjust, especially the new ones. When I was new, they're very helpful and friendly, Your Honor.
In the rendition of judgment, do you entirely refer that to your court attorney for drafting of the decision?
Well, in reality, Your Honor, since, well, it is public knowledge that the cases are quite many in the Court of Appeals and the records are voluminous, but we always discuss the ruling. In terms of facts, it would be easier for a justice to ask for a report as to the facts, but as to the ruling, that is the one that should be done by the justice and to discuss it with the court attorney, Your Honor.
So not an instance in your 10-year period with the Court of Appeals that you have referred a case to your court attorney for drafting of the decision?
Well, drafting, Your Honor, is part of our job. The drafting, the drafter.
That was what I was asking you.
Yes, Your Honor. Yes, Your Honor. What I am trying to say is when it goes to the ruling, Your Honor, the court attorney would already have templates of what we did in the past. That after discussion, that would be the conclusion of that certain set of facts. And hence, it would be easier, Your Honor, to complete the decision.
So in other words, after drafting the decision, you still review it.
Yes, Your Honor, of course. Yes, Your Honor.
Has there been a draft done by your court attorney that you adopted in toto?
Well, in honesty, I have very good, well, majority of them are very good, Your Honor, and they already know what I want, my style. I've already oriented them. I teach them what style to use, and it happens, Your Honor. It does happen in my office.
So how many cases drafted by your court attorneys that you had adopted in toto?
Adopted in total. Well, I always edit, Your Honor. I think nobody's really perfect.
Grammar, you edit the grammar.
Grammar, style and grammar, Your Honor. But usually the ruling, it's a template if it's the same or similar set of facts, Your Honor.
Are there certain judicial reforms that you would like to implement once appointed to the Supreme Court?
Your Honor, I've always thought of the bar examinations. I noticed that I think in the United States, the bar exams are supplemented by apprenticeship of law students or senior fourth-year students. Hence, the bar exams would not be the only standard to measure the capacity, the intellectual capacity of a would-be lawyer. It can be done by apprenticeship. It can be done in law school if it's the law school, if the law school is adopting strict standards, very strict standards, Your Honor, for the students.
You're speaking of the bar exams, how somebody can be accepted in the States. How about here in the Philippines? Is there do you need to reform this one?
There seems to be a technical glitch. Sorry, Your Honor. I did not get that.
You were talking of the bar exams in the States. Is that the kind of reform that you would plan to introduce in the Supreme Court once appointed to it?
Yes, Your Honor. If I'm blessed to join the court, I would propose that standards of law schools be maybe uplifted so that the bar exams would not be the only measure, but also law school, apprenticeship, because it's also very important to have the experience to litigate, to get into a courtroom, because some students have not even been inside a courtroom, Your Honor.
Okay, thank you, Justice D. That was my last question.
Thank you very much, Your Honor.
Thank you, Judge De Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Cuevas. Good morning, Justice Lisa.
Good morning, Your Honor.
The Court Appointments Watch Network submitted to us some questions they would like you to answer.
Okay, Your Honor.
What is your judicial philosophy?
My judicial philosophy, Your Honor, would first be dependent on the rule of law based on the laws and the rules adopted in our country. However, I also believe that since times are constantly changing and circumstances change, like now because of the age of technology, justices may also think out of the box in certain instances, Your Honor. And maybe some sort of judicial activism is called for in some cases.
Are you in favor of judicial activism? And if so, can you remember any decision of the Supreme Court which borders on judicial activism?
Your Honor, there was a case before as regards Article 26 of the Family Code, Republic versus Besido, penned by Justice Kisumbing. I think that was a long time ago. And it allowed the application of Article 26 to a Filipino who was naturalized abroad and obtained a divorce abroad, when the wording of Article 26 is actually alien spouse, quote unquote. So with due respect, Your Honor, I asked my mother, my late mother, about this because she was one of the framers of the Family Code. And she has always emphasized this in her book, Your Honor, that Article 26 really talks about an alien spouse. However, since there are so many situations where the Filipino, not necessarily an alien, would go abroad, be naturalized, obtain a divorce degree, and the same effect would happen, like the aggrieved spouse back here, for example, in the Philippines, would be alone and unable to marry if that provision is strictly applied to an alien spouse, quote unquote. Hence, when Republic versus Manalo came out, the ponensya of Chief Justice, the former Chief Justice, Gustavo Peralta, it was already very clear that this is already for the interest of the Filipino spouse left without a spouse because of the divorce obtained by the naturalized spouse or Filipino spouse.
Does the Constitution allow judicial activism, in your opinion?
I believe that other than the Constitution, Your Honor, judicial decisions form part of the law of the land. And when you say judicial decisions, the discretion of the magistrates are very essential.
If judicial decisions form part of the laws of the land, is that not tantamount to judicial legislation?
But it's already in the Civil Code, Your Honor, that judicial decisions form part of the law of the land. Judicial legislation and judicial activism.
Let me correct you on that.
Sorry.
Judicial decisions form part of the legal system. They do not form part of the laws of the land.
All right, Your Honor.
All right. Now let me go to another topic. Justice Lisa, what is your understanding of the doctrine of a living constitution?
The doctrine of a living constitution is one that deals with a constitution reachable to a person living his day-to-day life.
Is the Philippine Constitution, in your opinion, a living constitution?
Some of the provisions, Your Honor, are quite practical and applicable to the common Filipino, Your Honor.
U.S. Supreme Court Justice Antonin Scalia once said, when he was still alive, he said, I defend, excuse me, I defend a dead constitution. What do you think he meant by that?
Personally, my understanding of a dead constitution, Your Honor, is that the provisions are very hard to apply to one's day-to-day life. However, it does not necessarily mean that in the future, when circumstances change, when people change and technology would contribute to what happens, some provisions may resurrect, Your Honor, from the dead.
You're talking of the resurrected constitution? Is that what you're saying?
No, just the provisions, Your Honor, that were considered dead for a time, for a certain period of time. But in the future, it may come alive again when certain sets of facts may come and may be encountered.
Justice Scalia, when he said, I defend the dead constitution, what he was saying is that if it is in the constitution, it is there. And if it is not there, it is not there. In other words, he was a constitutional textualist. He applied the Constitution according to the text. Now, going back to the U.S. Supreme Court, recently, last month, President Biden nominated a judge, Judge Ketanji Jackson Brown, to the U.S. Supreme Court. And one of the questions asked of the nominee was something which she failed to explain adequately. And the question was, what is a woman? So if you were in her shoes, how would you have answered it?
Without going into biology, Your Honor, because I'm not a doctor, Your Honor, I would go into religion, that a woman is a creature of God, created by the Lord, created by God the Father to be a companion of Adam, Your Honor.
What do you think is the reason why the Senate Judiciary Committee, during the confirmation hearing, asked that question? Was it relevant?
I think they wanted to see the view of Judge Brown on women's rights.
On what issue?
On women's rights, Your Honor, if I'm not mistaken.
On gender identity. Okay, that was the issue. Should transgender who are biologically male but now considered female allowed to participate in a sports event participated by women? Is it constitutional?
I think that happened recently, Your Honor, in a weightlifting event. That a man biologically and transgender, that person is transgender, joined a weightlifting competition. And there were so many criticisms, Your Honor. I believe that it would depend on the rules of the Olympics, Your Honor, or whatever the sports body is.
Are constitutional issues involved? Is it fair to allow transgenders who are biologically male to compete in a sports event with females?
I would like to repeat my answer, Your Honor, that the rules of, in that case, the Olympics, would apply. Not necessarily the Constitution, Your Honor, because because of the nature of the event, Your Honor.
Women's volleyball is different from men's volleyball, correct?
Yes, Your Honor.
Women's basketball is different from men's basketball. In athletics, the female athletes were complaining that the transgender, who is biologically male, always came ahead as a winner in that event. Is it constitutional to allow them to participate, a transgender to participate in that kind of a sporting event solely dedicated to women?
Well, first of all, Your Honor, the aggrieved party should file a case, and this should be an actual case or controversy before we apply the constitutional principles, Your Honor, in court.
What is the difference, Justice Lisa, between a non-marital child from an illegitimate child? What is the difference?
There is a new case, Your Honor, I think penned by Justice Leonen, if I'm not mistaken, Aquino versus Aquino, where the illegitimate child, the word illegitimate is already not used, but non-marital. The Supreme Court already applied the word non-marital, especially in discussing the Iron Curtain Rule, Your Honor.
If a child is conceived and given birth by parents who are both single, do you consider the child, but the parents did not get married, do you consider the child non-marital or illegitimate?
As a rule, the Family Code provides for a situation where a child is born out of wedlock, Your Honor. That would be the situation of two single people who have a child. That would be out of wedlock because it's outside marriage.
No, my question is he considered a non-marital child or an illegitimate child?
Well, if we base the wording in the new jurisprudence, I would call it non-marital child, Your Honor. I would call the child
not an illegitimate child.
Well, illegitimate in the conventional concept, Your Honor, but it seems that the Supreme Court is already undergoing
menopause.
maybe a change.
My other question is, if a child is conceived and born from parents from an adulterous relationship, meaning to say one parent is married, the other is not, is the child considered non-marital or illegitimate child?
As a rule, it is as a rule, the conventional concept would be illegitimate because one of the parties is already married to another person. However, as I mentioned, Your Honor, the Iron Curtain Rule would like to give the child rights because the child is innocent.
We are not talking about the Iron Curtain Rule.
Sorry.
I'm talking of the nomenclature, the name given. Do you agree with the decision of the court that non-marital children are the same as illegitimate children, and that henceforth those who were considered as illegitimate children should now be considered as non-marital children? Do you agree with that? In your opinion, there are no right and wrong answers.
I believe, Your Honor, that the intention of the magistrates in promulgating that decision is to give the innocent child rights and to uplift such rights to avoid the situation that the child would feel inferior to a legitimate, compared to a legitimate child. That is how I understood the
Okay, my last
decision.
question is, are they on the same level? The example I gave, a child born of parents who are both single but did not get married, and a child born out of an adulterous relationship where one of the parent is married. Are they, in your opinion, are they, not talking as a judge, but are they on the same level?
Well, factually, Your Honor, not the same in a sense that a child of two single people may be legitimated. Like they can later on adopt the child, because that is one of the ways to legitimate a child based on the family code. Now, a child born of two people, one an adulterous person and another person based on such adulterous relationship cannot be legitimated, Your Honor. So in that way, they're different.
So you're saying the rationalization given by the court is that the child is innocent and you cannot impute the guilt of the parents to the child.
Yes, Your Honor. Yes, Your Honor.
Does it also apply to the issue of payment of real estate tax or estate tax?
Payment of real estate tax. Real estate tax?
What's the difference between real estate tax and estate tax?
Real estate tax is real property tax, Your Honor. Familiar, quote unquote. And estate tax is, of course, when a person dies, Your Honor, and there are taxes to be paid because of the death of the decedent.
Are the heirs liable to pay estate tax if they have not yet received their share of the estate?
Well, as long as the estate has been settled, Your Honor, and dissolved, and
When you say settled, you pay the debts
Yes, Your
and you
Honor.
divide
Yes, Your Honor.
the estate, correct?
Yes, Your Honor.
But my question is, are the heirs liable to pay the estate tax if they have not yet received their share of the estate? That's an academic question. Okay? It has no relevance to current events.
I believe so, Your Honor. They should pay the taxes.
Thank you very much, Justice Lisa, and good luck.
Thank you very much, Your Honor.
Thank you, Justice Tiham. Our next interviewer is the Honorable Judge Toribio E. Ilaw Jr.
All right. Thank you, Tony Marife. Yes, morning. Justice, you need the break.
It's okay, Your Honor. I'm okay.
What's okay to you?
What's okay? We can proceed, Your Honor.
You can proceed.
If we would like to
Because
proceed.
questions from here are so interesting that zeroing as to the gender insensitivity, gender languages, and I thought JBC has already been a Miss Universe contest. All right.
Good morning, Your
Yeah,
Honor.
because I'm being warned that the questions coming from with respect to the Data Privacy Act. And Justice, you're already 55 years old and still single.
Yes, Your Honor.
My favorite question is that,
I know.
you're being prepared for this.
I've broken my heart several times, Your Honor. Quite unlocking that department, but I have not lost hope in true love.
Okay, thank you. So single
Yes, Your
by
Honor.
choice or by chance?
Single by the will of God at the moment, Your Honor.
How about by chance?
Maybe by chance, Your Honor. because chance would refer to what happened in the past without my control, Your Honor.
Alright, this is the first time you are applying as an associate justice of
Yes,
the
Your Honor.
Supreme Court. Can you tell me something about yourself that is not found in your application requirements? Set aside being single.
Your Honor, before I became a lawyer, I was really a songwriter, Your Honor. I was a professional songwriter. Until now, actually, but I haven't had any new songs out. So when I was in college, they already know me as a songwriter, Your Honor.
Good. You still compose songs? Compose songs for singers as Regine Velasquez, well, Beauty Queen, and and also Shawi, the Emote Queen.
Yes, Your Honor. I have songs that they have recorded, Your Honor.
What inspired you to apply for this position?
Thank you for that question, Your Honor, because
You're welcome, always.
my mother passed away last November, Your Honor. And I will not lie to you, I'm still grieving, I'm still sad, I'm still adjusting to a life without her. And before she died, she was so very expressive, Your Honor, that I applied for the Supreme Court. So that was around 2019 before the pandemic happened. At that time, I was not yet in the right frame of mind to do it, Your Honor. Right now, I'm just taking my chance, Your Honor, and giving Mama what she wanted when she was alive.
Justice Alicia.
Yes, Your Honor.
And what preparations have you made to take on the challenges?
Well, first of all, I became chairperson already last November, Your Honor, the 17th Division of the Court of Appeals. So long before that, I was, of course, junior, then senior. I felt I did not have a chance, not yet at that time. But right now, Your Honor, since I'm already a chairperson, I believe that there might be a chance, Your Honor.
Imagine you are 55 years old. If and when nominated, the point that you're going to spend 15 years in the Supreme Court.
I love the work, Your Honor. This is the work that I learned to love. I discovered it when I was a court attorney here in the Supreme Court. I came from private practice and I discovered that adjudication is what I want to do, to write the decisions.
Boring. How about your life?
Love life.
No chance anymore.
I think if true love is willed by the Lord, Your Honor, it will happen, Your Honor, because God provides and love comes from mysterious places.
Anyway, if appointed, what do you believe will be your most contribution to the Supreme Court?
Well, looking at the Supreme Court right now, Your Honor, it's a very dynamic court. There are young magistrates like Justice Hernando. He's actually younger than I by months, Your Honor. And the dynamism, vitality, vigor, energy, Your Honor, and maybe creativity in ideas, innovativeness. I feel I can contribute in that way, Your Honor. If God wills that I join the court.
All right, browsing over your PDS, you have 46 cases which were unresolved within the reglementary period. Do these cases reflect your competence and efficiency as a magistrate?
Thank you for that question, Your Honor. The unresolved cases within 1 year resulted from a situation when I was transferred to Manila, Your Honor. I encountered a peculiar situation. There were only two of us who were transferred here at that time from Cebu. And during that time, I inherited old cases, Your Honor. So many old cases that I had to work on first. And the cases that were ripened during my time had to take sort of a back seat so that I could work on the old cases. There was one case that was even as old as 9 years, Your Honor. 9 years that have not been resolved yet, that was not yet resolved. And I had to look at those cases. And for some reason, Your Honor, we had this ICL, initial caseload given to us, 350 per justice, Your Honor. And most of them are old cases that I had to finish, Your Honor. And for some reason, more ICL would come and more older cases would come, Your Honor. So it snowballed. It just snowballed. But under the circumstances, I did my best, Your Honor, to resolve the cases assigned to me.
All right, then going back to your youth. If and when nominated, appointed, how do you plan to defend your ponencia to senior members of the Supreme Court? How are Justices Mon Hernando, Cholo, they're still young.
Yes, Your Honor. Well, in the first place, the senior justices of the court, I would defer to them by all means, Your Honor. But I'm sure that my ponencia, I will not write a ponencia without basis, Your Honor. Basis in law and evidence or evidentiary rules. Of course, I would defer to the views of my seniors because out of respect, out of their expertise, and they have been in the court for so long, Your Honor. But I would still do my best to defend my ponencia, Your Honor.
Would you be a liberal or a conservative justice of the Supreme Court?
I don't think I'm very conservative in a sense that my orientation, Your Honor, is to think out of the box since before. But of course, the parameters, the legal parameters are there to guide me, Your Honor.
All right, your late mother, Justice Elisa S D, was a member of the committee that drafted the Family Code of the Philippines.
Yes, Your Honor.
Is there any provision in the Family Code that you think needs amendment?
I think the one that I discussed with
Yes,
the good justice,
I didn't get
Noel.
that length. Yes.
Article 26, Your Honor, because of the word alien spouse. Although Republic versus Manalo already explained that when you say alien spouse, it does not necessarily mean a foreigner who would get a divorce abroad and divorce the Filipino spouse. But maybe just to clarify, maybe the word alien spouse could be amended and enlarged, Your Honor, so that it can include Filipinos, Your Honor.
All right, in the recent case of Malaki versus People, the Supreme Court ruled that conversion to Islam does not exculpate a person whose previous marriage was solemnized in accordance with non-Muslim rights from criminal liability for the crime of bigamy. What were the reasons cited by the court? Have you read this case?
I encountered the title, Your Honor, but very vague for the ruling.
Wait.
Yes, very vaguely, Your Honor.
It's in Malaki versus People, GR number 221075. It's November 15, 2021.
Okay.
Can you expound on this? How vague? Why do you say it's vague?
I just encountered the title, Your Honor, during one of the moments where we were past certain new cases, Your Honor. If I could just get the gist of the antecedents, Your Honor.
Now let's go to another case. Metro Manila Development Authority, represented by a deputized special counsel, and a private corporation entered into a compromise agreement, which was subsequently approved by the trial court. Although the Office of the Solicitor General has issued a deputation letter in favor of such counsel, it did not participate in the execution of the agreement, although it was aware of the negotiation leading to its consummation. Is the compromise agreement valid and binding to the government?
I don't think so, Your Honor. If the OSG was not allowed to participate in the talks for the compromise.
Yes, it's another case, MMDA versus High Desert Stopovers, Inc., CR number 213287, December 6, 2021.
Yes, Your Honor.
All right, my last and final question, Justice. Could you sing for us few lines of your favorite song? O hindi tayo, wala tayo sa Miss Universe contest, ha? Balik tayo sa kunyari sa Grammy. So, yeah, kahit konting acapella lang na medyo just to break the ice. Kaya doon nakakunutan doon natin dito na ano.
It's not the pale moon that excites me, that thrills and delights me. Oh no, it's just the nearness of you.
Thank you.
Thank you, Your Honor.
Thank you very much. Medyo naboboard tayo ng ano. Reminding me mamaya, magparto ba tayo mamaya? So just naroon di kumakanta. Thank you, Justice.
Thank you so
And,
much,
good luck,
Your Honor.
and thank you for being a good sport. And good luck.
Thank you.
Thank you, Judge Ilaw. The last to interview Justice D is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Maricel. Morning, Justice.
Good morning, Your Honor.
As a follow-up question, Judge Demonte asked you about equity. Very answer equity. And this is the basis of an action. How about natural law? What has our law say on natural law?
Natural law is a foundation of positive law, Your Honor. Hence, we can also apply natural law. And I believe that we can do that when positive law does not entirely apply or deal with a certain set of circumstance.
You mean to say there is no positive law, you can invoke natural law?
I think so, Your Honor.
What is your understanding of natural law?
Natural law is the law that governs the natural order of things, Your Honor. Not necessarily
That's
the...
physical.
Sorry?
That is physical.
Yes, that's part of it, Your Honor.
About moral law.
Moral law is also a foundation of positive law, Your Honor. It's also somewhat part and parcel of positive law.
But if there is I will read Article 1423 of the Civil Code. Natural obligations, not being based on positive law, but on equity and natural law, do not grant a right of action to enforce their performance. What is your understanding of that? Do not grant a right of action to enforce their performance.
From my understanding, Your Honor, such obligations do not grant a right of performance, but the judge can apply that law in a certain set of circumstances when it is necessary, Your Honor, and called for.
But the law says they do not grant a right of action to enforce their performance.
Yes, Your Honor.
What is your understanding of the phrase?
That means it cannot be the basis of a cause of action, Your Honor.
Cannot be the basis
In court.
of cause of action
Yes, Your Honor.
to enforce their performance.
I was thinking, Your Honor, of a certain concept like unjust enrichment, where there are certain facts in a case, Your Honor, where the judge can see the unjust enrichment on the part of a certain person and could award certain or grant a certain relief, Your Honor.
That is covered by under our
Civil code.
civil code. So it is positive law.
Well, yes, Your Honor, but I
If
think
it is- if it is written, it is positive
that's
law.
true.
So
yes, Your
natural law is not a written law. What is your concept really of natural law,
Natural law, I think it's more of science, Your Honor.
of physical?
Yes, Your Honor. Physics,
The
chemistry.
universal order,
Yes, Your Honor.
where it is man's basic understanding of what is right and what is wrong.
Thank you, Your Honor.
Now, I was listening also to your answer that decisions interpreting our laws form part of the land, but Justice Piham corrected me there.
Yes, Your Honor.
Forms part of the legal system.
Legal system.
Oh,
Sorry.
what is the difference between the two?
Legal system would include the judicial system, Your Honor. Adjudication,
That is very general. Can you be? Okay.
legal system, adjudication, litigation, how the lawyers would.
What is its effect? The interpretation of this means usually Supreme Court decision, right?
Yes, Your Honor. Based on.
That is different from what you have earlier stated. They form part of the laws of the land.
I believe.
Actually,
Sorry.
It form part of the legal system.
Yes, Your Honor.
How do they form part of the legal system?
Okay, the way we apply stare decisis, Your Honor, where a judicial decision does not only have persuasive effect, but also authority over a set of facts, over a similar set of facts before lower courts, that lower courts can look up to such authority, use it as a judicial authority in their decisions as a precedent, Your Honor.
They're not binding.
Well, to me, Your Honor, as long as all the elements of stare decisis are there, binding, Your Honor, binding upon parties, and even for the Supreme Court, for the judicial precedents of the Supreme Court,
We follow
binding upon lower courts and inferior.
upon lower courts only.
And
How about
court-
if you're the Supreme Court itself?
Supreme Court itself.
Well, anyway, you gave an example. Article 26.
Yes. Republic
Or
versus Manalo.
Republic versus Manalo,
Yes, Your Honor.
wherein under Article 26, it is supposed to be the alien spouse who obtains the divorce.
Yes, Your Honor.
So, in your view, even if it is the Filipino spouse who obtains the divorce abroad, he can stay, or he or she can still marry.
The Filipino spouse here
Yes.
can still will have that entitlement to remarry, Your Honor, based on
What
the
is
new.
the effect of that decision on Article 16 of the Civil Code?
As regards the nationality principle.
Yes. You're aware of that? What is the effect? Has it been rendered nugatory?
No, Your Honor, it's not. The nationality principle, from the way I remember that the Supreme Court
It follows our nationality.
we follow
Regarding what areas, what aspect?
marriage.
Or here, it was the Filipino who went abroad, obtained a divorce, he initiated the divorce, and then he can marry or he can marry.
Yes, Your Honor, there seems to be a problem before Republic versus Manalo came.
Yes.
I remember my mom was very violent about it because she said that it's that Article 26 does not apply to that situation. However, that divorce may be recognized if we are to enforce the rights of the Filipino spouse without a spouse, who is left without a spouse, Your Honor. So there is an unfair
So
situation.
it is allowing circumvention of Article 16.
Circumvention. I don't want to call it circumvention, Your Honor, but
Yes.
we are just thinking of the interest of the Filipino who was aggrieved by that spouse who obtained divorce abroad.
If the law is very clear, and the Supreme Court makes some digression, or about faith, not only digression, but about that's not judicial legislation.
Maybe it's closer to the term judicial activism, Your Honor, but not judicial legislation.
How about judicial overreach? What is your understanding
Overreach.
of judicial overreach?
For me, judicial overreach would be overreaching to the different departments, the
Yes.
other departments of government like Congress and the executive department, Your Honor.
Overreaching.
Yes.
And when the court holds itself, does not give due course or petition, what do you call that?
I'm sorry, when the court
That
does,
doctrine, what is that doctrine?
when the court does not give due course to a petition,
Yes, or denies the petition because it belongs to another department,
judicial restraint, Your Honor.
that is judicial restraint. Okay. Oh. Can you give me a decision where it was used?
where judicial restraint
Yes.
was used. I guess, Your Honor, certain decisions where judicial review was not,
That's very general.
I'm so, I know, I know, Your Honor, was not used because a certain act belongs to the sovereign power of a particular department, like the executive department.
So you're
Your Honor.
defining it. I'm asking you to give an example.
Example.
Anyway, about the Marcus Burial, was that an example? Is that an example of exercise of judicial restraint?
I think so, Your Honor, yes.
What is the doctrine of adherence jurisdiction?
I'm sorry, adherent,
Adherence jurisdiction.
adherence jurisdiction.
Yes.
When a court adheres to the authority of a certain body, Your Honor, or court, I'm sorry.
Anyway, there's another term for that. Once a court obtains jurisdiction for a case, it retains
The jurisdiction until the end
Until the end.
of the proceedings, Your Honor.
While a court, there is a case pending before a court. Can Congress enact a law depriving such court of jurisdiction?
During the pendency, Your Honor,
Yes, yes. The court has already obtained jurisdiction, but Congress went out of its way and enacted the law signed by the president, depriving such court of jurisdiction. That allowed?
does that law, Your Honor, I'm sorry for the question, but does that law provide for a retroactive application?
Yes.
Well, first of all, jurisdiction is provided by law, Your Honor. That's the rule.
Yes.
Now, since the case is already pending, it's already about to be finished, Your Honor, that
Depending, but no decision yet. Whether still starting or about to end.
I think they can do that, Your Honor.
They can do
Congress.
that,
Congress can pass that law.
such a law.
Then the lawyers can invoke it, Your Honor.
Okay. What do you call that legislation?
That kind of legislation on the part of Congress.
Yes.
When it passes a law that provides for retroactive application, ex post facto, something like that, Your Honor. If it's criminal,
Ex post facto.
only in criminal cases.
Is that your understanding of ex post facto?
In criminal cases, Your Honor. Only in criminal cases.
No, I'm speaking of all cases in general, even legal, even civil. We have so many decisions on that already. Remember the cases regarding labor, they were transferred to the
Yes, Your
labor
Honor.
department. They are called curative legislation.
Yes, Your Honor.
And the cases, you remember, the liquidation cases, at last fertilizer, they were taken from the present cases and placed within the jurisdiction of the liquidation court. You remember that?
Vaguely, Your Honor.
Let's go back to that iron curtain rule or the ruling in Aquino versus Aquino, which you are familiar with. The words in Article 9, I think 9 is very clear. It is covered by, they are under, the article is under illegitimate children. Right? Is it proper to use or to disregard it and place it under Article 987? You know Article 987? Because that was the article used by the Supreme Court in disregarding the iron curtain rule.
I think the Supreme Court only interpreted the provisions, Your Honor,
Yes.
to benefit the illegitimate child who will not, who is prevented from, let's say, inheriting from the legitimate line, Your Honor.
That is the provision of the law. It was disregarded. Actually, it was ignored, and 987 was used. What do you call that kind of ruling?
That kind of ruling of the Supreme Court, Your Honor.
Yes. Ignoring a law, which is the very issue in the case, and then applying another law, another article. Is that judicial legislation or judicial overreach?
I don't think it's judicial legislation because it just applied another portion of the civil code. Overreach, not really, because it is not encroaching upon another department like the executive or the Congress, Your Honor.
Because it is not, it merely ignored, it did not amend.
Yes, Your Honor. So I think it's more of
What is your
interpretation.
personal opinion?
It's more of an interpretation, Your Honor, based on the set of facts before the court, so that the illegitimate child will not feel so aggrieved, Your Honor, because he or she is innocent, Your Honor.
Anyway, I represent the retired justices of the Supreme Court. I will just ask questions coming from them. This one was sent by Chief Justice Gustavo Peralta before Justice Audrey applied. Are you familiar with Republic Act 11576?
11576.
Yes.
Could you kindly refresh me, Your Honor?
Yes. So, Republic Act 11576 allowed Supreme Court to raise the jurisdictional amounts of the first and second level court. You know, remember?
Okay.
Okay. In that legislation, the Congress delegated legislative power. Okay? What is the rule on delegation of legislative power?
Well, the general rule is legislative power cannot be delegated, Your Honor, because potestas delegata non potest delegari. However, if the delegation passes the two tests, Your Honor, completeness test and sufficiency of standards test, then it will be allowed, especially if the legislative power per se is not the one being delegated, but maybe more of the implementation thereof.
Okay, you mentioned two tests, completeness test and sufficiency test. What is the completeness test?
The completeness test provides that the delegation should be complete in itself.
It's very general.
I know, yes, Your Honor. In a sense that the delegate will not have the chance to apply its own policy and discretion outside the law which is delegated, outside the law on which the delegation is based. And the sufficiency of standards test is that there is a standard in the law that the delegate should follow or observe in implementing in acting as a delegate of Congress, Your Honor.
Well, a law is complete when it lays down a sufficient standard, when it provides adequate guidelines or limitations in the law to map out the boundaries of the delegate's authority and prevent the delegation from running riot. They use the word running, sorry. Sufficiency standard, the standard must specify at least three things. What are those?
The standard, Your Honor?
Yeah, the sufficiency test, sorry.
Well, it has to be determinable in the
Yes,
law. Determinable in the law. Determinate.
three
Your
aspects.
Honor. Determinate, meaning it is fixed, Your Honor, so that the delegate will know what to do in its observation of such standard.
There are three.
It is expressly provided in the law.
Yes.
Yes.
Specify the limits of the delegate's authority to announce the legislative policy, and three, identify the conditions under which it is to be implemented. In Republic Act 11576, was there sufficient standard?
Just to clarify, Your Honor, I'm sorry, the Supreme Court was given the power
Yes.
to increase the amount of the claims that a lower court may take cognizance of. First of all, the standards, well, I'm honestly, Your Honor, I don't know how the Congress
You forgot-
fashioned the
You
standards.
forgot the wordings already. It's
But-
all right.
But
It's all right.
yes, Your Honor, but
Do you remember? No.
well, since it happened already, Your Honor, maybe the Supreme Court exercised its rulemaking power under the Constitution.
Just because.
It's part
that
of it.
reason.
It's one of the reasons why it was
There
given.
was do you remember the standard set by Congress? If you do not know, okay lang naman.
It's okay.
No.
I cannot remember, Your Honor.
Okay.
Sorry.
This was asking the 2006 bar, what is the doctrine of auto-limitation in political? 2006 bar,
Auto limitation,
principle of auto-limitation.
something to do with sovereignty, Your Honor. That there are certain limitations to a state's sovereignty, Your Honor. In a certain situation, there are limiting factors, Your Honor.
Can you elaborate on that? It's all right. I have, this is a question from Justice Rio. Can you distinguish between strict construction and strict scrutiny of statute?
Your Honor, strict construction has something to do with statutory construction, the way the court would construe a law. Now, strict scrutiny, Your Honor, is one of the tests laid down in the later jurisprudence laid down by the Supreme Court relating to infringement of fundamental rights.
That's correct. Verse 1 refers to the interpretation, legal hermeneutics, and strict scrutiny is one of the three tests. What are the two other tests?
Rational test, Your Honor, where the rationality of the government act is scrutinized, and then intermediate test where there is a suspect of an infringement of the right, and hence this entails more scrutiny, Your Honor.
What was the first one you mentioned?
Rational test,
Rational test.
rational basis test or something.
Rational basis.
There's a rational basis on the part of government, Your Honor.
Still from Justice Brion, what is your concept of unprotected speech?
Unprotected speech. Unprotected speech. There are certain situations where the government is allowed to enforce laws to somewhat enforce a compelling interest, Your Honor, not to protect a speech, a certain kind of speech
There is a compelling interest.
on the part of government.
Should there be a compelling interest?
Because the rule is speech should be protected based on,
Okay, we go to another point. When is compelling state interest used? The standard.
well, for freedom of expression, Your Honor. May I go to the tests first, Your Honor? So, well, clear and present danger rule, dangerous tendency, and the balancing of interest test, Your Honor. Now, in clear and present danger rule, that is the most libertarian of all tests, Your Honor, where the government's interest somewhat takes a back seat, Your Honor, because it should be clear that there is an imminent danger based on that speech, based on that particular speech. Now, dangerous tendency is more used for the benefit of government because tendency, there is slight tendency, and the government will say it's already dangerous, Your Honor, and hence speech will be unprotected. for dangerous tendency. Now, for balancing of interest rules at test, the court will balance the interest of both government and the person exercising the right.
Those are the three tests.
Yes,
It's different from the levels of scrutiny.
well, I believe, Your Honor, the levels of scrutiny are more applied by the Supreme Court in equal protection clause violations, Your Honor. Like if you say rational basis test, that's the word, Your Honor, rational basis test, that the Congress is presumed to have a reasonable basis in coming up with a law dealing with equal protection, Your Honor.
This is from Justice Ascuna. What is, in your view, the best Supreme Court decision?
The best Supreme Court decision.
That is a question of Justice Ascuna. I represent them.
Yes, Your Honor. That would be Estrada versus Escritor to me, Your Honor, personally. Because it's a triumph of religious rights against governmental interest, Your Honor.
And you have read a lot of decisions. Where would you have dissented?
I think I mentioned this to Justice Tiam a while ago. The Echegaray decision, Your Honor, People versus Echegaray. Because there, the Supreme Court.
Yes, I had read that. You personally do not believe in the death penalty.
As a Christian, Your Honor,
Yeah, you do not believe in the imposition of death penalty.
I do not believe that it is a deterrent to crime, Your Honor.
Yes.
Yes, Your Honor.
Now, but suppose the death penalty is imposed, is resurrected, is imposed again. Is that constitutional or not?
Well, actually, it's already in the Constitution, Your Honor.
Yes.
It just so happened that it had been suspended. The application of the death penalty had been suspended for heinous crimes, Your Honor. If it is reverted by law, I have no choice, Your Honor, of course, because there's a law already, Your Honor.
There is also a decision regarding that. Remember that? The judge in Manila who refused to impose the death penalty.
Yes, I remember, Your Honor. I appeared before him. I think I remember.
Now this is a question. This I have no more time. From the court appointment, what? They submitted so many questions, but I will just ask one. How will the court renew confidence and assure due process in the judiciary in an age where social media is often the platform for grievances?
Well, I believe, Your Honor, first of all, I'm happy that the Supreme Court has reached more court users through the internet, through Twitter. The PIO has a Twitter account, and I'm not sure about Facebook, Your Honor, because I'm not an active Facebook user. But the fact that it has used social media to reach court users, it is a good way to renew the people's faith in the judiciary as an institution, because people can express their views in such platforms, Your Honor. So in the digital age, I believe that the court has already maybe revolutionized itself from being an unreachable institution to something that the people can relate to. And if you see Twitter, Your Honor, they can really talk to the PIO on certain issues and matters, Your Honor.
Do you agree with what the PIO is doing?
Yes, Your Honor, I do.
Why is it that in the surveys, the judiciary is still regarded, not highly regarded?
Well, first of all, the members of the judiciary are not politicians, Your Honor. We are not here to do the popular act, to make popular decisions, or to be friendly, or to fraternize. But we are here to adjudicate, to do the work based on the rule of law, whether or not it's harsh to the people, Your Honor, compared to the politicians, Your Honor.
Thank you very much, Justice. That will be all. I agree with your last answer.
Thank you so much, Your Honor. God bless you.
Your excuse already, Justice. Thank you.
Thank you, Justice Mendoza. Thank you, Justice D, and good luck po. We will have a 5-minute break, Your Honors, before we proceed to the next interview. Thank you po.
Oras hindi ko malap.
Interview this morning is Court of Appeals Associate Justice Apolinario D. BRUSELAS Jr. You may have.
Good morning, Your Honor.
Our interviewer is Honorable Judge Franklin J. De Monteverde.
Your Honor, please, may I be permitted to remove my mask if allowed so that I will not be impolite to the JBC?
Yes, you go ahead.
Thank you, Your Honor. I tested the negative for the antigen.
Okay. Sige. Thank you, Attorney Cuevas. Good morning, Justice.
Morning, Your Honor.
Yeah, okay. We have thoroughly interviewed you the last time you appeared before us, no? So there's only one question that I would like to ask from you. This is an update on a case filed by a certain Mohit Dargani, which until now remains pending. Can you brief us on this?
Yes, Your Honor. That is the case where the Senate Blue Ribbon Committee committed into custody 3 employees of, I think, Parmali. One lady, then Mohit Dargani, and another one. Mohit Dargani and his sister, I forgot the first name, were directed to be taken into custody because of their failure to abide by the Senate investigation rules. They were held in contempt of the Senate, and as a consequence of that, they were held in custody until they are able to comply with the requirements of the Senate. So the case came to us via a writ of habeas corpus, and in January this year, or late January, the lady had been released from custody. And we issued a resolution saying that insofar as she is concerned, that petition is moot. She has been released. But firstly, Your Honor, let me just backtrack a little. When that case was filed with us, we issued a preliminary resolution because in a petition for a writ of habeas corpus, the court has a choice of whether or not to at once issue the writ and direct that the person in custody be brought by the custodians of the court, or if the court sees from the facts indicated that there is a need for a preliminary matters to be addressed, that's what we did. We issued the resolution directing that preliminaries be addressed and ask the respondent, Senate, Sergeant at Arms, etc., to submit their comment. And they have done that. And now, Your Honor, the status is we are in the process of resolving that. Because why the little bit of delay? Because there have been changes brought about by the reorganization in the Court of Appeals, Your Honor. And as we reorganize, new members come in, new members join the court. And secondly, Your Honor, it was also because when we started with that, the lockdown was still, I think, alert level 3. So that's the status of the case, Your Honor. We did not issue at once a writ because the court felt that the matter being, the petitioners were actually held by virtue of a local authority, that is the Senate. It would have been different if, prima facie, you would have seen that there is no local authority which directed that they be held in custody. That is the situation, Your Honor. We are not in delay because we are well within the time allowed by the rules for resolving cases, Your Honor.
Okay, Justice, but I'm referring to the case now docketed as control number CDS 1113. It's now with the JIB. So kindly attend to this, huh?
I'm not aware of that, Your Honor, but I will take Your Honor. Thank you very much.
Okay, sige. So that's my only question now, Justice.
Thank you, Your Honor.
Thank you, Judge De Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Cuevas. Good morning, Justice Paul.
Good morning, Your Honor.
I will just read some questions forwarded by the Court Appointments Watch Network. What is your opinion on online cross-examination? Does it infringe upon the right of the accused to confront and examine the witness?
Well, first, Your Honor, in an online hearing, our rules in criminal actions where there is an accused, as you have stated, our rules require that the accused must consent to an online hearing. And if he does consent to an online hearing, then that means to say he will abide by the rules of evidence, direct examination, cross-examination. Now, in that question, do I agree with that? Well, as I said, if the accused consents, no problem. But if the court insists on an online hearing and requires that the examination of a witness be online, and there may be some problems with respect to that. But concerning virtual hearings, Your Honor, nowadays it is easy. Technology has been developed to an extent that it is now easy for parties in different localities to be able to converse with each other, just as what we are having now. And so that therefore, examination of witnesses virtually can be done. But I think we have to refine this further, especially in criminal actions, because when a witness is cross-examined online, the judge may not see, if he is also online, the judge may not see the exact demeanor of the witness, the twitch on eyelid, the flick on finger, etc. So there are things that may not be seen by the judge who is online. Thank you.
My second to the last question is another question from the Court Appointments Watch Network. It reads, what do you think about copy-paste search warrants being prevalent in this administration? How will they tackle this issue? Have you come across what is alluded here as a copy-paste search warrant? Is there a way, as a justice of the Court of Appeals, when you review criminal cases elevated to the Court of Appeals and there is an issue regarding the validity of a search warrant, how do you, are there telltale signs to ascertain whether this is a so-called copy-paste search warrant?
As of now, Your Honor, we have not encountered a particular case concerning copy-pasted search warrants. What we have encountered are cases involving questions where the hearing is done online. We have encountered that. Now, with respect to this one, copy-pasted search warrants, what are my thoughts on this? I think this can happen because right now, with the lockdowns, etc., the trial courts have been given the opportunity to carry out their trial duties via virtual conferencing. And also they are connected virtually. I know for a fact that trial courts do issue search warrants electronically. There is a provision for that, but that is probably where it came, where a search warrant is issued electronically and somehow it is accessed in the net and it is copy-pasted. The danger of these so-called search warrants issued in the net is that the net can be hacked anytime. Even if it's secured, there is no such thing as a foolproof security. So that is where it can happen. Somebody, a malicious person, can capture a search warrant issued online by a trial court and then edit that and put some names and have that enforced by an officer gullible enough against somebody who is not even supposed to be arrested. That is the danger, Your Honor.
My last question is also from the Court Appointments Watch Network, protection of human rights. Can you cite a decision of the Supreme Court that sought to protect human rights?
There is one, the case of Almoro, which has been partly resolved. As a matter of fact, we have used that in our decisions in the court. The more case, that's the case where the campaign against rampant use of drugs, selling of drugs, where we have, I think it's the Oakland double barrel. And the Supreme Court there stood strongly in favor of civil liberties. The Supreme Court required that information be submitted by the law enforcement officers concerning the cases which involve numerous victims of, shall we say, killings. No, it is the police say it is part of the performance of their duty, but on the other hand, the victims say that they have been summarily executed, and the Supreme Court actually intervened, and in that case required the law enforcement officers to submit information concerning the investigation that they had conducted with respect to these numerous cases. And the Court of Appeals, in fact, in one of my decisions, we cited that as in support of the court's disposition.
Thank you very much, Justice Paul, and good luck.
Thank you, Your Honor.
Thank you, Justice Tiham. Our next interviewer is the Honorable Judge Toribio E. Ilaw Jr.
Thank you, Attorney Marife. Anong latest, Marife? Wala. Anyway, just good morning, Justice Paul.
Good morning, Your Honor.
How are you today?
Very pleased to see you again, Your Honor.
Me too. Yes, you've been Associate Justice, Court of Appeals 16 years. 6 years, 6 in seniority in the Court of Appeals. You had been previously nominated for the Supreme Court Associate Justice. That's 14 times.
Yeah, I think so. Yes,
More than 14 times.
I have lost track of the number, Your Honor.
Yes, just for the record, 2014, you were nominated 3 times. In 2016, twice. 2017, 4 times. In 2018, twice. 2019 and 2021, twice. A total of 14 times. So the Pandora's box of nagging question is why, for heaven's sake, you had not been appointed?
First, Your Honor, I would like to thank the JBC for consistently nominating me. Second, Your Honor, the question, as they say in a courtroom, when a witness is asked a question which he cannot answer, as they say, the witness is competent, Your Honor. I would not be able to answer the question, Your Honor, because it's the appointing authority who would be in possession of that answer to that question. I can only surmise, I can only infer that perhaps the others who have been appointed were much better than I am, Your Honor. That could be it, Your Honor.
I know that that's not true. By the way, what is your reputation in the office? How would your superior, justices of the Supreme Court, colleagues and subordinates describe you, both positive and negative? There's something wrong?
Difficult question, but there is, it's both. I think they say that, I said before, suplado. Mahirap kausapin yan si Justice Bruselas. So it's some say it's positive, some say it's negative. We live in a world where there are people, so you should not be antisocial. My retort to that is this: the precise profession that I am in requires restraint. So I mean that's probably why I behave that way. I am they perceive me as suplado. It's because we have to be careful about whom to elbow rub with, whom to join, because we decide cases involving many citizens of the country. And we would like judges should portray their independence and impartiality. These are the principles: integrity, propriety, principles which judges must be able to convey to the public. Because if they do not do that, then the public will not be able to believe the decisions of the court. That is probably why, Your Honor, as I said again, I can only surmise. But
That's all that I can say, Your Honor.
That's negative.
I said, Your Honor, it's both positive and negative, depending on how one views it. But I really cannot understand. I'm not antisocial. I mean, I've been in the court for 17 years, in the judiciary for a total of 25 years. I spent 8 years in the RTC, then 8 years as public prosecutor before that. So a total of 36 years in government service. Before that, I had spent 3 years in the Armed Forces of the Philippines, Judicial Service. And when I was rated out, I was rated outstanding before I left the service. So that's it, Your Honor. And also, I've been recognized by the Supreme Court and the Foundation for Judicial Excellence as a best trial judge in 2003. That's why I was appointed. One of the reasons why I got into the Court of Appeals early on. I really do not know, Your Honor, what others may say of me, but I am never bothered by these things, so long as I know that I am traveling the straight and narrow path, and I prejudice no one. That's all that I can say, Your Honor.
Do you believe that to be a magistrate is a big deal? You have to be aloof with your friends, community?
To be a judge, Your Honor, does not mean that one must be aloof. To be a judge simply means that one must recognize and be aware of his public conduct and behavior. It doesn't mean to say that one should shun away society and be a hermit and live elsewhere like the mountain people. Not at all. But it simply means a modicum of restraint. So in other words, the default rule of a judge should be one of restraint, propriety. If a lawyer were once a gregarious personality, then when he enters the judiciary, he has to temper his being gregarious, because that may not sit well with the rest of the public. But of course, as I said, being a judge is something that one must realize that will require restraint. It is an awesome responsibility to be a judge. If one does not realize that, then that's where we have GIB cases. I think that's where we have GIB, because judges who are unable to assimilate, to digest what it is to be a judge, well, will sooner or later find themselves before a disciplinary authority.
Because I remember what I asked an applicant for Chief Justice, why don't you just smile? But I believe that you can smile every time, everywhere. That's that's a reminder for the National Mental Institute. You smile.
That's right, Your Honor. Smiling is, in fact, it activates the muscles in the face. It is a healthy attitude to be smiling. Of course, too much smiling may also be considered as something wrong in the person. It's really moderation, Your Honor, moderation.
Now, what has changed since your last application, Justice BRUSELAS? This is my favorite one, considering that you've been nominated so many times. That factors, that credentials that this time may strengthen, or that the president may be convinced to appoint you if nominated.
What has changed, Your Honor, since my last appearance before the esteemed members of the council? Well, one, I am now the chair of the 5th Division of the court. I am what we call an elder in the Court of Appeals. Second, I am now the chair of the Internal Rules Committee. The Internal Rules Committee of the court is they call it a go-to committee, too powerful committee. The third one is I am also, well, I have retained my chairmanship of the Computer Precision Library Modernization Committee. It's a long name. We intend to change it to Committee on Information Technology. The fourth one is we are now, I and other justices have been at the forefront of pushing the PJP 365, the what we call the platform for online hearing
online processing of cases, no, using MS-365. We call it PJ-365. The Supreme Court has acquired licenses for about close to 1,000 for all trial courts to be equipped with this. And we are at the forefront of pushing this and having this propagated, having this understood by trial judges so that they can better perform their duties. And what else? Well, we have been swamped with cases because of the pandemic, and we are trying to whittle that down. So that is what has happened, Your Honor. No travels, no trainings, online trainings. That is what we have attended, Your Honor. That's it. Those are the things that have transpired since we met, Your Honor.
All right. If appointed to the highest court, how do you maximize technology and social media in the Supreme Court?
Well, right now, the Supreme Court has, as I said, acquired licenses, MS-365, no? We call it PJ-365. What we're having now is one of those things that the Supreme Court has acquired, allowing us to have a hybrid meeting, face-to-face, and also somebody in attendance online. So this should be pursued further by the court, but of course, some refinement, especially with the question asked by Justice Noel Tiham about online examination of witnesses of the accused. We have to fine-tune that matter with respect to criminal actions because there may be some problems. But by and large, Your Honor, the technology has actually contributed to a faster processing of cases. Apart from the amendment of the various rules of procedure, apart from that, the technology that we have now has allowed the courts all over the country to process cases despite the pandemic, despite the lockdowns. So, of course, a little bit slower, but it has not stopped trial courts from functioning with technology. So it is an important, as a matter of fact, I had said before that this should be a priority project of the Supreme Court. Whoever is the Chief Justice, whatever administration, that should be pursued relentlessly because it will help. It is a tool for efficiency, a tool for transparency.
But here's one of the questions given or suggested by the Court Appointments Watch Network. The question is, how will the court renew confidence and assure due process in the judiciary in an age where social media is often the platform for grievances? That indeed is an aspect of the technology that has to be addressed, that has to be grappled with by the court. Years back, a circular was issued advising judges to be wary of being engaged too much in social media. There was a reiteration of the circular. Now, my take on this, social media indeed is the proliferation of social media has been aided by technology. That is a source of many conflicts. In fact, a source also of controversies. That's why, with respect to those who are on the bench, judges must be fully aware of their being engaged in social media. If they do chat, they do Facebook, they do Viber. That's like a highway. You cross the highway and you are liable to be run over by speeding trucks. That's it. You know? That's why if you're a judge, best to limit yourself in engaging in Facebook. That's also a platform for all kinds of information, true, untrue, fake, false, so that the one who is enamored with social media will find himself or herself perplexed by all of this information. But what can we do? We cannot curtail the right of the people to express themselves, to articulate. That's the other side of the coin. I think one of these days a precise case might be brought to the Supreme Court for the court to be able to set guidelines and parameters
for this.
All right, Justice Paul. In your PDS, you stated under references, persons not related on you by consanguinity or affinity, persons having knowledge of your personal or professional background. And you stated upon request your references. Could you provide this council a list of your references now?
Yes, Your Honor, I will gladly. In the past, I have written down the names of these references, but I don't know. Later on, I thought it may be best to just leave it blank and just provide the names of references upon request. But I will provide, Your Honor, the council a list of names of who can vouch for me. I have been in the court for, as I said, 17 in the Court of Appeals, 18, 25 in the Judiciary. Chief Justices have worked with Chief Justices, and I am sure they can vouch. They'll know me. I just don't want to put names of persons up there because it may appear that I'm trying to use their names for this and that. But the JBC, even in their private time or to the staff, can inquire from the previous heads of offices of my conduct and behavior. Incidentally, Your Honor, now that we talk about it, the other new thing is I'm now the chair of the Judicial Conduct and Ethics Department of PhilJA. That's the new thing, Your Honor. So that probably explains why I am a little bit reserved, and I try to keep to myself, Your Honor. It's difficult when you are chair of that department because you have to walk the talk, so to speak.
Will you provide us now a list, even some?
Verbally, Your Honor.
Yes, please.
Well, when I was appointed to the Court of Appeals, Chief Justice Davide was the Chief Justice. So Chief Justice Davide, he would be one of those who would be able to know my person. And then after that, Chief Justice Panganiban was appointed. Then Chief Justice Puno. And then our, of course, well, the one I work with now, our presiding justice, Mid Salazar Fernando, whom I have been with since I joined the Court of Appeals. Those outside of well, as you know, Your Honors, the late Senator Vic Siga, who from yes, Vic Siga, he expired during the pandemic. We are family friends from Tabaco Albay, so close family ties.
Vic Siga, yes, the senator.
Yes, Vic Siga. The mother, Teclas, the Senator Teclas and Siga, the first woman lawyer in the Philippines, was my professor in UP Law School, and she was a commander of my father. So close family ties. Vic Siga is an elder.
Vic Siga, a known drinker.
Yes, Your Honor, a US Law graduate. US Law graduate. About the drinker, Your Honor, I'm not aware of that. Maybe I don't know what he drinks.
All right, your case your current case load is 4. How do you manage your docket, Justice?
In the Court of Appeals, I was partly responsible for putting up what we call the Court of Appeals Case Management Information System. That is a computerized way of tracking all cases from docketing up the way it is promulgated. All justices of the Court of Appeals have the facility to look at this through their computers, whether it be a laptop or desktop. If they are, if they are only in the habit of opening their computers day in, day out, they will be able to see the movement of the cases assigned to them. So what I do is I look, because there's an aging. Automatically, you can age by the push of a button. You can push a button, and the computer will display the aging of cases every day. There's a counter that says case number 1 is already 20 days old. Case number 2 is 3 months old. Case number 3 is 1 year old. Then these cases are submitted for decision. How long have they been submitted for decision? So and so. So I target that, Your Honor. I target those which have aged, the older ones. First in, first out, Your Honor. That's how I manage. I think that's how all the others do. That's why the Court of Appeals has been able to reduce the number of cases that are submitted for decision beyond the 12-month period. The Constitution requires that a case before the Court of Appeals must be decided, resolved within 12 months from the time it is submitted for decision. Now, largely because of automation, computerization, we have been able to get into that window of 12 months. There are a few outliers, but mostly within 12 months, cases in the Court of Appeals that are submitted for decision are decided within that period.
And what do you think are the reasons why there are magistrates who maintain high court dockets? Can you answer for them?
In the past, Your Honor, in the past, many colleagues were engaged in other activities. Some are, some are engaged in,
In golf, what?
well, perhaps it's part of getting healthy, physical, but they have other activities that they attend to, which somehow interfere with their ability to be able to look at their cases and act on them. Of course, not to mention the fact, Your Honor, that even if a justice is so studious and so diligent, remember that he has two other colleagues in the division. No matter how fast he works, if the two other colleagues is not able to keep with the tempo, then naturally that justice who is very, very fast will have to be pulled down. So it's really a teamwork amongst the division members to get into sync the way they work, to include their other activities, Your Honor.
I'm going to remember that when PJ is not here, maybe there are other preoccupations of justices in the Court of Appeal.
What I meant by that, probably some have more time doing teaching, field work or teaching in other schools. I've always maintained the fact that I used to teach before in the evening classes. I said, we teach in the evening. We cannot teach other than that time because daytime, we're supposed to be on our desk doing our work. But somehow I think there's an overlap. I'm not so sure. That's why I said, I've been telling PJ, perhaps we should look at this, and even Philja, look at how we judges and justices whom we used to help us out in our activities, let us program it in such a way that they are not taken out of their main work. What is the main work? Well, for a judge, his main work is judging. He's not teaching or doing something else. But of course, because we want to improve ourselves, perhaps some of our colleagues, spend time teaching because they want to improve themselves. Perhaps forgetting that there is some job there to attend to.
All right, my last and final question, Justice. What is the question people ask you most often?
People ask me most often.
Most often.
First, Your Honor, as I said, because of my social life, I try to limit my social life. So there are not many people who come up to me and ask questions of me most often. But those occasions where I have had the chance to mingle with people, the question that recurrently is asked of me is a matter of why is it taking so long for decisions to be made, etc., etc. So I explained to them. I said, insofar as the Court of Appeals is concerned, because that's what I know, where I come from, we have been able to reduce that so-called delay. Perhaps you are perceiving that from eons ago. It's not a new matter. I said, why don't you open your computer, go to the internet, and check the website of the Court of Appeals, and you can see there the cases that have been moving. We post there cases that are decided day in, day out. The Supreme Court also has a website. I think JBC is part of that website, which tells the public that this is what's happening. I think the public just lazy. I mean, just used to the old information about delay. Because it's easy to publish, no? It's something that is hot all the time. The truth is, the court, the judiciary is addressing in earnest that question of delay.
All right, thank you. That was my last and final question. And again, Justice, good luck.
Thank you very much, Your Honor.
I hope that's going to be the 15th time for your nomination.
Thank you very much, Your Honor.
Thank you too. All right, welcome. And good luck again.
Thank you, Judge Ilaw. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good morning, Justice.
Good morning, Your Honor.
I have extensively asked you before. Now, there is nothing new in your record except this pending control number CDS 11135 by Mohit Dargani, which was touched earlier by Judge De Monteverde. What is this CDS? What do you mean by CDS?
Frankly, Your Honor, I am not aware of the JIB matter. In fact, I am part of the monthly JIB seminar workshop where we disseminate to the judges the new JIB rules, and we also have a workshop on ethical standards. I am not aware of that JIB CDS, Your Honor. It could have arisen from what I said earlier about a case brought to the Court of Appeals, which is with us, which we have partly resolved. And that is a contempt case against them, and they are questioning the custody. I mean, there's only one now. Mohit Dargani is questioning the legality of his custody.
This is still pending.
Yes, Your Honor, as I said earlier, because the differences, the organization, etc. But we have resolved that partly. The sister has been released by the Senate. Just to lay it bare, Your Honor, the petitioner there is questioning the legality of his custody. But as I said earlier, that's why we required the Senate to comment, because preliminarily, there is a lawful authority, that's the Senate, that
Yes.
directed their custody. The court cannot just ignore that as a matter of course, Your Honor.
Is there a limitation on the period of imprisonment under the inherent power of contempt of the Senate?
I remember the case of Arnold versus Nazareno.
Yes.
It was an early case concerning this. Mr. Arnold was...
We all studied that.
Yes, Your Honor. As we know, he spent months in custody until I think an event supervened, or until he finally cooperated and answered the questions required of him by the Senate. So there is, as I know now, there is no period, because that is the Senate in its
period. What is the difference between the Senate and the House of Representatives' power of contempt, as explained in Arnold versus Nazareno?
I am not, very frankly, Your Honor, the details of that case I cannot recall. But wasn't Arnold decided by in a case where there was a National Assembly unicameral? There were, I'm not so sure, but
You're not sure?
yeah, very. I will have to admit, Your Honor, that the details of that I'm not so sure about. The difference between
the distinction between the Senate and their powers of contempt. Well, in the Senate, it is a continuing body. There is no time limit in the exercise of its power to punish for contempt.
remember, Your Honor, I remember.
Yes.
As
On the
against
other
Congress.
hand, the House of Representatives is not a continuing body and has a limit in the exercise of its power to punish for contempt, which is on the final adjournment of its last session. Do you still believe that this is applicable?
the principle that the Senate is a continuing body is sound principle. As a matter of fact, now we are electing 12 senators. There are still 12 remaining members. So Senate is a continuing body. The House of
So
Representatives,
the Senate has no limitation.
insofar as the Senate is concerned, because
No
there are
limitation.
always 12 of them in the Senate. So recalling now that Arnold, I think that's the basic difference. The House, they are only good until their last day in office, so that whatever orders they may have issued will become functus officio. It will lose effect because there is no longer a lower house to speak of.
Are you aware of the case of Balag versus Senate of the Philippines?
Balag, I have not encountered. I'm so sorry to say, Your Honor, but that case is I cannot. The title is maybe if the facts are recollected.
It's related to your case. It was written by Chief Justice Esmundo. So if you say that the Senate has no limitation, you would have written a dissenting opinion in this case, because Justice Esmundo wrote, the rules that the legislative inquiry of the Senate terminates on two instances. One, first, upon approval or disapproval of the committee report. And second, the legislative inquiry of the Senate also terminates upon expiration of one Congress. So will you still maintain your position that it has no limitation?
If that is the Supreme Court's decision on that matter, I cannot, given the limitation of my knowledge of the facts, I have no basis of.
But do you agree? Do you always agree with the Supreme Court decision?
We agree for the purpose of stare decisis, for the purpose of not disturbing what has been decided by the court. It's also for order hierarchy, because imagine a court of appeals that decides otherwise. What will that telegraph to the public and the trial courts? So we follow the principle that a case decided by the Supreme Court will be a ruling case insofar as those facts are concerned, and will be followed all the way down the trial courts.
You have read a lot of Supreme Court decisions. Where would you have dissented?
Well, in a past interview, Your Honor, I was asked that, and in that case of Chief Justice Luke Bersamin penned his ponencia about appointments, the power of appointments of a president. I think that involved Chief Justice Corona. May a president appoint within the 60-day period prior to the next election. The Constitution provides that no appointments may be made, or no appointments may be made 60 days prior to the next election, except only for temporary appointments, which continued vacancy will prejudice public service and endanger public safety. So those are two exceptions.
So you disagree with the ponencia in De Castro. You're referring to De Castro.
You asked me, Your Honor, when I will
Yes.
disagree. That is probably one point. Academic discussion. That's this not to say that we are not
I
following
will
that.
not take it against you. Just an opinion.
Yes, that's one, Your Honor. As a matter of
How about the provision under Article 8
but
that the president should appoint within 90 days?
that is what was used, Your Honor, that provision in Article 8 of
There is that provision.
was precisely what was used in
You
the
ignore
argument.
that provision.
No, we do
So
not.
you mean to say that the succeeding justice can be appointed beyond 90 days?
De-
That
Definitely.
is your position.
No, no, Your Honor. That must be harmonized. Meaning to say,
How do you harmonize it?
well, for if there is still a remaining time for Supreme Court justices,
Suppose there is no remaining time.
well, if there is no remaining time, and but if you compute that, Your Honor,
From
it's,
vacancy, and there are
yes,
Article 8.
from vacancy, from vacancy.
90 days from vacancy.
In that case, Your Honor,
The
there should,
president will not appoint. There is no compliance with that 90-day period.
as I said, Your Honor, on the other hand, those are provisions which the Supreme Court
They are conflicting
has
provisions.
interpreted, Your Honor, and the Supreme Court, in its wisdom, interpreted it that way. Now you're asking whether I agree or not. I am saying that perhaps, I think I may have
Perhaps only
I may have written something else about it.
you would have decided otherwise.
I may have written some because I would
You
maintain.
would have written a separate opinion, if not dissenting.
I may have had that, Your Honor.
What would have been your separate opinion?
I as I said, well, this is our opinion. We are talking about facts that have transpired. But if that is revisited, probably, Your Honor, my position will be to put that Article 8 provision on the president must appoint within 90 days in the context of the election period. I mean to say that should be harmonized with the Article 7 provision on appointments not to be made before 60 days of the coming next election. That's what my position is, to harmonize that.
How do you harmonize?
Well, I would say that what is the preference? We would go now to the what is the preference of what is in what the Article 7 says. No appointments may be made within the 60 days prior to the next election, except only for temporary appointments in the executive. So we are talking about judicial appointments. We are going to say now that
Supreme Court only.
yes, Supreme Court,
Because
yes.
in the lower court, we do not speak of the Constitution does not speak of 90 days.
It's from the list, the submission of the list,
Yes.
not the
From
vacancy.
vacancy.
Yes.
Yes.
So it's a really a very political issue because many factors are considered here. First, when the vacancy came out and the vacancy was processed, meaning to say it was opened up by the JBC, by the Supreme Court. Then how many days were left for the president to be able to act? So my point is that the 90-day period, Your Honor, it's quite inconceivable to have a situation where the president will not be able, will be circumscribed by that circumstance that he should appoint within 90 days. Because there is another provision that says do not make appointments before 60 days,
So you
except
you
only.
reconcile.
Yeah, but I would say that what would exempt the judicial appointment is the appointment to the Supreme Court a matter of prejudice to public service or will it endanger public safety? While those are the parameters used for temporary appointments in the executive, I would say that there should be no reason why that should not also be considered. That is one way of doing it. Difficult thing to do, Your Honor, orally, verbally. It needs a lot of thinking and analyzing, Your Honor. Difficult to analyze verbally and answer directly, Your Honor, because these are difficult questions. As a matter of fact, the Supreme Court in De Castro was not divided, was not unanimous. It was a divided court.
That's why I'm asking your personal opinion.
That's why
I will not take it against.
That's why I gave my opinion, Your Honor. That frankly, I would have gone to the other side. That
But with respect to the contempt, you read the case of Ballard versus Senate. Now, I will go to another point. Just recently lang kasi ito, hindi na sana ako magtatanong. Have you heard of the Iron Curtain rule in succession?
think that refers to a law was recently passed.
Law?
There's a law that took up the reserva troncal. Apart from that, a decision came out from the court that does away with that reserva troncal principle in succession. That's what I recall. Your Honor.
Reserva troncal involved with in Article 992.
Are you referring to the case of Billy?
Aquino versus Aquino. We asked Justice Lisa about it because her mother,
Family court.
yes,
Family court.
the author of the family.
I think that case now puts the
Before you go
illegitimate.
further, do you know
I remember.
what is the Iron Curtain rule in succession?
It prevents those whom we call illegitimate children. Now we call it non-marital children.
Yes.
No? There is the better term, as the Justice General puts it. Says illegitimate is pejorative. So let's call them non-marital. So children who are offsprings of parents who were not married. So that case now, I think, puts them, that's this non-marital children, removes that bar from
That
for
bar.
them to inherit, to succeed
From?
from their their parents, though they may not be married, no? Because that's I think, yeah, before, if you are illegitimate non-marital, there is no right to succeed from your father or the mother, as the case may
If
be.
you're illegitimate, you can succeed from your parents. But
1/4.
992 refers to grandparents.
Yeah.
And it bars inheritance by
If
grandchildren.
in case
if illegitimate, that is 992.
they
But in Aquino versus Aquino, they were allowed.
In-
Or do you think so?
in case there's a predeceased, predeceased, no, the parents predeceased the grandparents. So that is a direct succession for non-marital children. They represent the parents who have died ahead of the grandparents. I think that's the case where the non-marital children are now allowed to represent their biological parents who have died ahead of their grandparents. So they can succeed directly.
Still under that same provision, 992?
I'll be very frank, Your Honor, I'm not a family court judge, and the nuances about that.
Baka lang nabasa mo, okay lang. Yung 992 refers to, that is the Iron Curtain rule in succession. But the Supreme Court avoided that and said the child can inherit under Article 982 of this code. It is very general because 992 is under illegitimate children. So the Supreme Court seems to ignore 992. What do you call that? Is that not judicial legislation?
Is called interpretation
It is.
of the provisions of the law. When the court does interpret the law, it does not legislate as a matter of course of the primary work of legislating. It is an incidental, a consequence of their interpreting the law. That is what Marbury Madison said. No? When the court does this, it's only as a consequence of its power of judicial review to interpret the Constitution.
What is judicial overreach?
Well, judicial overreach is when they call that a situation where the court goes beyond what are within the four corners of the case before them. They extend, they do everything. That's what I understand, judicial overreach. Is it good or is it bad? These are situations where the court has gone not beyond the boundaries of their powers, but they have tackled other things other than what should have been tackled alone on the square.
such a case, the court should have refrained from tackling them.
Well,
In case of judicial overreach.
that principle of restraint, judicial restraint is something that should be also considered. Courts, as I said, generally should confine themselves to the case and controversy, the very least mota of the case. But it cannot be helped that sometimes in the court's desire to expand, enlighten, and deepen their analysis, they could probably do an overreach. But judicial restraint is an important principle that courts should also remember. May I just quickly say, Your Honor, that I got confused about that. There is servo truncal, there is a legislation. The other one that you said is yes, by decision. I got confused about that. Your Honor.
I know you have not read Aquino versus Aquino, right?
Not that, Your Honor.
Okay. That will be my last question. Thank you very much.
Thank you very much, Your Honor.
Your excuse na dyan.
Thank you very much for the opportunity to be again before the council. Thank you very much.
Thank you, Justice Mendoza. Thank you, Justice Bruselas, and good luck po.
Five years kasi po. 5 years pa.
Candidate to be interviewed today is Court of Appeals Associate Justice Ramon A. CRUZ. Good afternoon, Justice CRUZ. You may take your seat. The first to interview Justice CRUZ is the Honorable Judge Franklin J. De Monteverde.
Okay, thank you, Attorney Marife. Morning, Justice Mon.
Justice.
Good morning. Good afternoon na pala. Okay, I have interviewed you twice already, and I'll just ask you an update on your health condition. There has been a medical report which says that you have a slightly elevated fasting blood sugar, uric acid, triglycerides, and bad cholesterol. Kindly give us an update on this, Justice.
Yes, Your Honor. I show it to my doctor, a cardiologist, and he gave the view that at my age, it is a bit normal to have those kind of ratings because they are not really that high, albeit they are a little bit above normal.
So yes, as a matter of fact, the report says that you have a minor findings only.
Yes, Your Honor.
That will be all for you, Justice Mon.
Thank you.
Good luck. Good luck.
Thank you.
Thank you, Judge De Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Cuevas.
You're welcome.
It's noontime, but to give premium to your presence today and the fact that you prepared for this interview, I'll ask you just a few questions. Justice Mon, there was a case decided by the Supreme Court last November, the case of Malaki, spouses Malaki versus People. Have you read that case?
I really am not familiar with that, Your Honor.
Okay. A married couple converted to Islam. Is it legal for the husband after converting to Islam to marry for the second time?
If the purpose, Your Honor, of converting to Islam is to escape from prosecution, then that conversion to a different faith would not be taken as defense if that is a criminal prosecution.
Supposing the conversion is in good faith, can the husband be prosecuted, in your opinion, for bigamy?
Good faith, I think, Your Honor, it's a matter of intention. So it will really depend on the circumstances of a case. But I remember a case, albeit this is an administrative case, decided by the Chief Justice Puno. This involved a court employee where he was charged for immoral conduct. He was exonerated in that case because the reason being that there is no really immoral conduct there because of religious belief.
To read the case of spouses Malaki versus People, Ponencia of Justice Leona, November 2021, a party to a civil marriage who converts to Islam and contracts another marriage, despite the first marriage subsistence, is guilty of bigamy. Likewise, guilty is the spouse in the subsequent marriage. Conversion to Islam does not operate to exculpate them from criminal liability. All right, my last question. Can priests, members of, can priests and bishops engage in partisan politics, campaign for candidates? If yes, do they violate any constitutional prohibition?
A priest, Your Honor, regardless of the denomination that he belongs, is still a citizen. He has a right, he has a freedom of expression, he has a freedom of expression that he is entitled to exercise. So on the basis of the constitutional right, if that the priest really could expound his view who the particular candidate that he is going to side with. But the problem there is when he influenced the people who to vote for, then there lies the difference. There could be a line that he breaches.
What about the so-called separation of church and state? Is this infringed upon? When a priest or a bishop engages in partisan political activity?
The wall between the state and religion consists of the pre-exercise clause and the recognition of a particular candidate. The view by a priest that as long as it falls within his freedom of expression, I guess that could be constitutionally permissible.
Right. Thank you very much, Justice Mon, and good luck.
Thank you.
Thank you, Justice Pihan. Our next interviewer is the Honorable Judge Toribio E. Ilaw Jr.
All right, thank you, Attorney Marife, whoever. Please do not stress my first name naman, Toribio. Nakakawalang gana kumain. Anyway, it's very rare yan. Don't you remember that Toribio is it's a certain Teodoro Toribio, the owner of the Antibay. Yumaman niya ng time ni Manuel L. Quezon. Okay, thank you. Yes, Justice, good afternoon. Good afternoon, Toribio. What's the time? Yeah, it's past 12. You need to have a break, Justice?
No need, Justice.
When after Justice Bruselas, as how many times was he nominated and this position 14 times, and for your record, you have been previously nominated for 8 times.
Yes, Sean.
And since your last since your previous application, what steps have you taken to strengthen this time your candidacy for this position?
The last 2 years, Your Honor, prevented us from maximizing our abilities. But then last year, I was invited to be the resource speaker of a student association. And lately, I've been asked by some members of the Supreme Court to be a member of the technical working group working on a possible revision to the rules on criminal procedure. That I guess basically would be for the last year or the last 2 years would be the training that I had to enhance whatever ability I have.
By the way, how is your work performance? That is one that slightly improved from 16 average monthly disposition when you applied in June 2021. Now it's 21 as of this present application.
Before I came over, Your Honor, I asked my staff how many cases there are due in my docket for decision. They informed me that as of last week, which is the end of the end of the month, I had 0 cases submitted for decision.
Under your references, you mentioned a certain Attorney Fred Lim. Which this delayed Fred Lim?
No, Your Honor. He is a good friend of mine from Bicol.
Bicol, from Pagcor.
Yes, Your Honor.
Had you worked with him in the professional capacity?
I use him as my reference because I've known him for so many years already. When I was still a practicing lawyer, he was also a practicing lawyer, and we would occasionally or regularly meet. So he knows the kind of job that I do. When I was a judge in Quezon City, sometimes he would drop by and say hello, and we would talk about we would talk about the legal, the salient features of the law, but not these cases. So I told myself that he is a good person to use as a reference.
How about this retired Judge Marvel Clavicilla?
In the same way also, he's also from Naga, Your Honor. When I was RTC Judge Sinaga, he too was a judge there. So because he knew what the nature of the job that I do, then I told myself also that he could be a good reference.
Mga Uragon. Why do you use Uragon in Bicol? Is this a bad?
No,
or
a good
word?
Uragon simply means that you are strong, you are a good person.
And lastly, is this Nick Acosta?
He is also, Your Honor, he was a colleague of mine in the Court of Appeals. He know my reputation. He know the kind of work that I do.
All right, Senate Bill number 2450 seeks to confer permanent validity of certificates of birth, death, and marriage issued, signed, certified, or authenticated by the Philippine Statistics Authority. If passed into law, do you perceive any disadvantages?
The question there really, Your Honor, is, this is my personal thought. Why would it need authentication when that is the governmental agency that is tasked to issue this kind of documents? If when say that governmental agency issues that particular document, it would carry with it the fact that it is authentic.
And the follow-up question is about this national ID, the issuance of the national ID.
Well, that could be legally permissible because times are changing. There is really on the part of the government the need to synchronize all transactions to the government, simplify all things, and the issuance of a national ID may serve its purpose.
All right, Justice Monda, how do you keep abreast with the recent legal and developments in law and cases?
I am a professor of law, Justice. I teach criminal procedure at University of Asia and the Pacific. And sometimes, well, the pandemic for the last 2 years prevented us from doing this. Sometimes I would lecture at NCLA, and sometimes I'm also invited by the PILJA to conduct some seminars.
Asia Pacific is a college of law.
Yes, Your Honor, there is.
The question is just with respect to a recent case decided with the court. May private enterprises exercise the power of eminent domain through delegation by the Congress?
Yes, Your Honor. I think it is a decided case. If I am not mistaken, there is an electric company somewhere in the south, which was expropriated, and that issue cropped up. That issue was issued in the affirmative by the Supreme Court, even if the delegation was considered to be or was treated to be valid.
The popular one, the controversial one, More Electric.
Yeah, I think
Power
so.
Corporation versus Panay Electric Company.
I think so, Your Honor.
By the way, at previous applicants have been asked by the retired justices with respect to iron curtain rule. What is this
Iron curtain, yeah.
curtain rule?
That is the bar prohibiting or barring illegitimate siblings from inheriting up into status from his or her siblings for a sentence of children. That is, I think, the iron curtain bar.
All right, my last and final question, Justice. What is one thing that you will never say to another person?
Well,
Ano? Sabi mabawi niya.
there are, but fairness dictates really that I keep it to myself, that even if you do not, if you really hate that someone, you have to keep it to yourself. You do not have to tell that someone that you do not like him.
Like to be an hypocrite.
Precisely, Your Honor. You just have to be. You just have to keep you just have to keep to yourself. You're thinking of that other person.
If one is tsaka, sasabihin mo maganda.
No, Your Honor. What I am saying is you have to keep it to yourself that he or she is maganda.
All right, that are my last and final questions.
Thank you very much.
Judge.
Thank you very much.
Good luck again.
Thank you, Judge Ilaw. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good afternoon, Justice.
Good afternoon, sir.
I represent the retired justices of the Supreme Court, so I will just ask you the questions they proposed that I asked. So, this is from Justice Ascuna. What is the best decision ever rendered by the Philippine Supreme Court, and why do you think it is so?
There are lots of good decisions by the Supreme Court, Your Honor.
He's asking only one.
Only one. The case decided by Chief Justice Puno on economic matters, where he wrote forcefully something on economic matters, which some economic managers question. The economic managers pointed out that it was the court now touching on economic matters. But that decision, I think it was the Manila. I really could not recall the exact citation. Declared as unconstitutional a particular executive order.
Have you read the case of Republic versus Sandigan Bayan? The Elizabeth Dimano case?
When was it decided, Joe?
Oh, a long time ago, but to Justice Ascuna, it was the best decision. Up to now, it is the best decision by the Supreme Court. Do you have any idea why?
If
It was during that time, there was a revolutionary government, and the government of people who controlled them confiscated or sequestered the properties of the mistress of General Ramas. The name of the mistress was Elizabeth Dimano, so it was called Elizabeth Dimano case. What do you think was the decision of the Supreme Court then?
because I think that it was a decision which explained the right of the government against an individual
Yes.
and constitutional right of a person. And
Do you remember the case?
I'm trying to remember, Your Honor, but I think that was along that line.
Yes. What was the decision of the Supreme Court?
It was a clash between the governmental right against an individual
Right.
liberty.
Yes. Yes.
And I think that the government there was sustained because of of the situation than prevailing.
The government was a state.
Yes, Your Honor.
You know that the Supreme Court ruled otherwise.
Well, as I was saying, Your Honor, I read that
Said
case,
because
but
there was at that time there was a revolutionary government. There was still no
there was a functioning constitution.
1987 constitution was not yet promulgated. 1987. According to that decision, even if there is no constitution, the governing law should be the internationally accepted international law on rights. That's why he said, according to him, it is the best decision of the Supreme Court. This is also from another justice. He came from the Court of Appeals also. Because environmental laws are under the jurisdiction of the Court of Appeals, currently Supreme Court. There is a unique litigation tool called ISLAP. What is ISLAP?
That is a provision under the law on writ of kalikasan where
Yes.
An individual could
What
be
does ISLAP stand for? ISLAP.
yes, Your Honor. I know what slap means. That
Yes.
is yeah. That is
Acronym for what?
that escapes me, Your Honor, at this point. But I know the background. I know what it is.
Strategic
Yeah.
lawsuit against public participation. Briefly, can you tell us the procedure?
In writ of kalikasan cases, Your Honor.
If you cannot remember, it's all right.
Yeah. Yeah. Are you asking for the?
Anuhin mo lang si Justice Joey. Si Justice Joey nagpatanong sa iyo. Si Justice Brian naman, what is the difference between strict construction and strict scrutiny?
There are cases, Your Honor, strict construction with refer to how the Constitution must be interpreted. That it must be interpreted in accordance with the words that it says. While strict scrutiny would refer to a person freedom. It would refer to first freedom cases touching on.
But it is what?
Yeah, that statute.
Construction, the first interpretation.
Yes, sure. That is statute with affecting.
Strict scrutiny is what?
Strict scrutiny is would refer to the construction that must be given by the court.
No.
On-
It refers to the standard
Yes, Your Honor.
judicial review.
That-
There are three standards for judicial review. One of them is strict scrutiny. What are the other two?
That the strict overbreadth and the broad test.
Strict scrutiny and the way you review your constitution on that. A justice yun. A justice yun. The other justice, what is unprotected speech? Also from Justice Brion.
An unprotected speech, Your Honor, is one where or would refer to utterances or words made in disregard to a particular norms or values. Like the Brandenburg test, Your Honor. Oh, well, strictly, well, when a speech, a hate speech falls within the protected speech. But if it is done in order to, when it becomes inimical to the interests of the society, then it becomes an unprotected speech.
This is from Chief Justice Peralta before his wife applied for the position you're also applying for. Do you know what is Republic Act 11576?
Republic Act 11576.
It pertains to the expansion of the jurisdiction of the first level courts.
Yes, Your Honor. Expansion.
In that law, the Congress delegated to the Supreme Court the authority to adjust the jurisdictional amount of the first and second level court. Is there a valid, this is the question of justice, is there a valid delegation of legislative power?
If that law, Your Honor, delegating to the Supreme Court the authority to increase the jurisdictional threshold is complete in all its force, that there is nothing more on the part of the Supreme Court to do but to implement it. Then it is a valid delegation. But we really have to consider also the fact that even sans delegation from Congress, there is a question whether the Supreme Court could do that under its rulemaking authority.
Yes. What is due delegation of legislative power?
Due delegation.
What are the two tests? What are the two tests?
If the law that Congress passes is complete in its form, that there is nothing more that we delegate to do but to implement it, then that is a due delegation of power. And or if what is delegated given by Congress to the delegates merely to fill in the details, then that is also a due delegation of authority.
You mentioned the completeness test. The other test is what?
The standards, Your Honor, that there should be standards on.
Yes, there should be standards. What do you call that test regarding the standards? Anyway, it's the sufficiency standard. This is very basic. A is married to B, and A refuses to support B, so B filed an action for support. A interposed the defense that the marriage is void for lack of marriage license, is she allowed to invoke that defense?
For lack of marriage license, Your Honor.
Yes.
That is a case for support. So, marriage, I guess, could not be attacked collaterally.
Cannot be collaterally attacked.
Yes, Your Honor.
Anyway, read the case of Minal versus Batayo, and also the case of Castro versus Visual, where collateral attack of the validity of marriage was allowed. Do you know the case of Pulido?
Well, Polito, the case of Polito refers to the defense of nullity of marriage in a prosecution for bigamy,
Yes,
where the court ruled that an accused may raise as a defense, and a good defense at that, if he could raise the validity of either the first or second marriage as a defense in a case for bigamy.
you need not wait that it be declared, judicially declared.
Yes, Your Honor, as ruled in that case.
So you read Pulido. You also read those two cases. I think those are my only questions for today, Justice. Thank you very much.
Thank you very much, Justice.
Thank you, Justice Mendoza. Thank you, Justice Cruz, and good luck.
Thank you. Salamat.
That concludes the public panel interview for today.